is a founding partner of Acuna Regli. He is a California State Bar certified estate planning, trust, and probate law specialist. Mr. Acuna is also a featured speaker for the Professional Fiduciary Association of California, the National Guardianship Association, and the California Public Administrators, Public Conservators, and Public Guardians. He advises tax, fiduciary, and investment professionals. Tracy Regli is a founding partner of Acuna Regli as well. Tracy focuses her practice on probate and trust administration, fiduciary representation, conservatorship, and special needs planning. She is an active member of the Alameda and Contra Costa Bar Associations, the Professional Fiduciary Association of California, and the Southern Alameda Estate Planning Council.
By the way, if you can't tell the difference between Frank and Tracy, the competency seminar is across the hall. Tracy, you want to start us off?
Well, I feel kind of bad for the guy videoing us. You know we move a lot, right?
I've already warned him.
Okay. So good morning, everybody.
Good morning.
I'm glad this isn't even your first session. You guys were up and at it early this morning, I hear. So now you're ready and pumped for us, right?
Yes.
Let's try this again. So you're ready and pumped for us, right?
Yes.
All right. So before we start up, what kinds of things are coming up in your practices? What are you seeing as the litigation hot topics? What do you want to talk about today? Because we want to make sure that we're addressing you. So open to the floor. Or are you just going to let two attorneys talk and fill the room with hot air? Yes, ma'am.
What's coming up for me is that there are feuding families and you're in litigation, and then all of a sudden you get a call saying, oh, they've decided that you are now going to be the successor interim trustee. And
Congratulations.
So is your problem the problem of battling beneficiaries, and how do you communicate with all these characters?
exactly.
Okay, so we are definitely going to be talking about communication tips with battling beneficiaries. Somebody else. Yes, ma'am. Good to see you. Hey, there's calling me sir these days. That's just wrong.
What we've had issues with are private trusts. We had 3 private trusts with beneficiaries turning us into the bureau. And many people here, I had that experience too, because they were cleaning out all of their backlog at the bureau. And it was all beneficiaries complaining because they didn't understand the accounting.
Okay.
Not that they didn't get it, they didn't understand.
I'm starting to get a theme here about communication and making sure the beneficiaries understand. Anybody else with something that they want us to cover today? Yes, sir.
Forms of fiduciary business organizations.
Fiduciary business organizations. Do you know that, 6 years ago, they wouldn't let us talk about that in continuing education? But we are talking about it. That's a different class, though. This is one of the things that could help is how you're organized, having a continuation plan, a business succession plan. But that's not properly what we're talking about today. Today we're talking about where's litigation coming from? What are the trends in litigation? Anybody else? Anybody on this side? Oh, yes, ma'am.
Durable powers of attorney.
Durable powers of attorney? How?
Our public guardian's office is always calling me to act as durable power of attorney. No conservatorship, no trust, just durable power of attorney, paying people's bills for maybe mentally challenged people, and I always say no. Because I think that it's a possible problem, just paying people's bills when you're not competent.
So you're having
Well-
the problem, do I even have authority to act? And how do I stay within the 4 corners of my authority?
Exactly.
Okay. Okay. Yes, sir, in the back.
The administering a trust of a beneficiary, like mom or dad, and keeping the residual beneficiaries informed
Okay.
as far as the accounting is.
Again, communication. That's going to be a big theme. Yes, sir.
We gather once a year here to sit through these sessions and be told how much liability there is in our business and all the things we need to do to protect ourselves. But I'm just curious, how much litigation actually involves professional trustees versus lay trustees or beneficiaries fighting with one another as opposed to actually involving the fiduciary?
That's a great question. The question is, Is this really a hot topic, or is all the litigation going on between beneficiaries and family member fiduciaries? I'll give you my own impression. Family member fiduciaries mess it up a hell of a lot more than the professionals. That's why you're here. You get stuck in 2 years into the end of the mission. T?
So my take on it is, I actually did a trial with a fiduciary this year, and it started out as battling beneficiaries, but you would be surprised how quickly that turns when they realize they're not going to get any money out of each other to looking at the fiduciary. So while I like to think that there is not a lot of litigation specifically starting out against the professional fiduciary, it's really easy for you to be caught in the crosshairs.
And my own perspective on this, truthfully, I have heard from a lot of professional fiduciaries, some fiduciaries who told me they don't need errors and omissions, malpractice insurance. If you go to the office without malpractice insurance, it's on you. Period, end of story. Mostly because your E&O insurance pays us when the beneficiaries turn and decide that they're going to go after you instead of each other. Okay, one last person had. Yes, sir.
Yeah, trustee fee agreements, which I think is an add-on to what we were just talking about.
Trustee fee agreements, we can definitely talk about a little bit about that. And for those of you who have time tomorrow morning, Tracy and the fiduciary who went through trial together, that's their course, is they're going to actually walk you through that trial and what happened, what were the ups, what were the downs. So let's take a look at some of the things that we're seeing. First thing that we're seeing, first trend we're seeing is failure to fund subtrust. I have a case in the office right now where the father died. It's a blended family, second marriage. It was one of those short-term marriages. It only lasted 25 years. But dad died in 1986. And stepmom, it was a bankrupt estate, and stepmom worked her bottoms off to pay off the creditors, and now in 2017, we have a demand letter saying you never funded the subtrust. Imagine, if you will, if there was a professional fiduciary involved. So failure to fund subtrust is kind of our first area that we're seeing. Tracy has, how shall we say, Tracy has a unique perspective on this because she's the trust administrator and I'm the estate planning attorney. Tracy.
Well, where I see fiduciaries, professional fiduciaries, when I say the term fiduciary for our purpose, I am always talking about a professional. We also represent non-professionals, but where they tend to get caught, obviously, if you're administering the trust from the onset and a spouse dies, you guys know to split the trust. You're very experienced. What ends up happening, though, is you come in years later, the first spouse has been dead for 10, 20 years. The surviving spouse was doing just fine, and now he or she is starting to fail, and they're bringing you in. And lo and behold, it called for a split at the first death. We're a lot of years into this trust administration. What are we going to do? I mean, that's where it really, I think, comes into your context. Again, if you are brought in from the beginning and the first spouse dies, you know how to split a trust. But that's not usually how you're brought into these things. Much like her, you're usually brought in kicking and screaming, no, I don't want to go, I don't want to go, don't make me do this.
And realize Tracy she's a purist here. She is a trust administrator. She's going to look at that trust and say, you've got to split it. For those of you who've dealt with your clients and they're getting older, especially now that the exemption equivalent, the tax-free amount has increased to $5.5 million, my attorney never told me that I would have to split the trust. It was supposed to be all mine when he died. But that's not what the trust document says. And a family member is going to have enough of a problem. A professional fiduciary is going to have a real problem. So remember that you've got two types of trust typically for married people, the mandatory AB trust, and then you have the discretionary kind of disclaimer trust that can be split at an option. The other kind of thing out there is you may have an AB trust, but some trusts have a waiver. They say that you don't have to actually physically segregate the assets, but you do have to account for them separately. So the number one hit right here is check the doggone trust document. And more than check the trust document, make your attorney work. Before you take that case, make the attorney review the document and tell you what kind of trust you're dealing with and what the funding formula was. And was it properly funded? Yes, ma'am.
In situations where you're taking over from a family trustee, you might have already exceeded the mandatory guidelines or whatever, fill in the blank. So what do you do at that point to protect yourself from litigation? Because though the beneficiaries may be or may not be more forgiving of the family member, there certainly things that you should have been able to fix everything. How do you fix if you've exceeded?
The question, I'm going to repeat the question. The question is, well, what happens? I'm the licensed professional. This has gone on for a number of years, and nobody ever funded the subtrust, or they did so and they did so inadequately, or they did so and they didn't follow the formula whatsoever, and now I'm here. What do I do? Trace.
So the first thing that I would advise my fiduciary, because they've come to me early on and we're evaluating whether or not this is even an appropriate case for you to take, whether it's something that you want to get into, what the possible risks are, what the possible benefits are. And something that Ms. Hand brought up yesterday in her presentation that we also advise our clients and think it's a good practice is let's look at what the problems are. You guys are paid problem solvers and you're really good at it, but it's not always your job to solve the problem. Are there some problems that should and could be fixed before you step into that role? And where you've had maybe a family member fiduciary, maybe not the surviving spouse, but maybe the oldest child who's been administering this trust and never split it and years have passed, maybe it's his or her job to fix that before giving it to you. Maybe a petition for instructions to the court, maybe waivers from the other family member beneficiaries, something of that nature before you even get involved in it. However, life is not always ideal, as the gentleman back there recognized. You come here once a year, we tell you the best practices, but this is also a business, and it's a high-stress business and a high-crisis business. So while we'd like to think that we call you on the phone and very calmly say, we'd really like to give you all of the facts and circumstances about this case and let you mull it over for a few days, and then maybe you'll decide to take it, and you'll do some research, and you'll talk to your attorney, it generally goes more like this. Hey, I have this, and there's 3 things, and I need you to act, and can you do it? And I need a commitment in 15 minutes. Can you call me back? I mean, that's more realistically what you guys are faced with a lot of times. So if you find yourself in a situation where you now have the trust, you are the trustee, you realize it hasn't been split, the first thing we're going to look at as your attorneys are, okay, what is the damage here? I'm going to use mom because mom usually statistically outlives dad. So
Wait, before you go on, does anybody know why mom outlives dad? Okay, I'm going to give it to you here. You're going to learn something that you're not going to learn in any other seminar. It's really simple. God, in his infinite wisdom, created men with warm legs and women with cold feet. So what happens every night of our married lives are those cold toes go right back here behind our knees. And it chills the blood supply to the brain, and it knocks us off 7 to 10 years early because of the cold blood supply to the brain. Ladies, I do not want to hear you griping about him not putting his shorts in the hamper, because short-term memory is the first to go after you've had your brain cells chilled by the cold blood. Okay, now you can go ahead. I'm here for you, brother.
So you found yourself in this situation. So the first thing we're going to assess is the damage. Has mom made any changes to the trust? If she hasn't made any changes, in all honesty, no harm, no foul. All of the beneficiaries are actually going to be super happy because they're going to get that second step up in basis at mom's death. They're actually going to see a benefit. Where you potentially have problems, though, is mom has changed the trust, or worse yet, stepmom has changed the trust and completely written out dad's people. While that rarely happens, almost all the time, that's where we really run into a problem. And that's where your attorney is going to advise you, we're going to have to go back and figure out how to split this trust one way or another, and we're going to need to get agreement. Yes?
Well, the same issue would be if there are different beneficiaries
And that's really what I'm talking about. So if there's been no changes, well, I guess you're right. If they created the trust together and the B trust and the A trust had separate beneficiaries right from the start, you're right. Then that definitely creates a problem. Although that is almost more easily rectified, because if it really was supposed to be 50-50, those beneficiaries are going to benefit from the step-up in basis, which they never would have benefited from before.
So the very simple agreement may be that you go to all the beneficiaries and say, look, here's your problem. We do not have a taxable estate. Yes, there have been changes. Surviving spouse had the right to change the survivor's trust, but let's agree that what we're going to do is treat the entire estate as half his, half hers, or half first spouse, half second spouse. And then at the end of it, when second spouse dies, we get the complete step up in basis, and we do it all as bookkeeping rather than as actually funding the sub-trust. Now, some families will do that, some families won't. So we're going to get to that second point where I'm going to say, people, yet again, I love Tracy's thing, make that previous trustee, make that previous beneficiary take it on the chin. Let them do their accounting, let them make their proposal and figure it out. And if that doesn't work, if you're already in the game, then I am a big believer in using Section 17200 as quickly as possible. Because I want the court to see that you got on the scene, you saw the problem right away, here's your solution to fix it, and then let the beneficiaries battle it out, and you're what you're supposed to be, not the person who forgot to do it, but you're simply the neutral stakeholder who said, hey, we got a problem here, let's fix this. Gary.
So how do you protect a fiduciary if you've gone through that settlement, you have a 17200 order, and the IRS isn't a party to that?
Again, remember, if we're talking about a non-taxable estate, what's the IRS penalty for not dividing into subtrusts? They treat it as one estate. Okay, if it's under $5.5 million roughly, you got no harm, no foul. You're gonna have a non-taxable estate, and you're gonna get the second step up in basis. I don't see the IRS as having a problem there.
And if you have a taxable estate, you're going to pay that tax one way or the other. What they missed out on by not splitting that trust was the tax savings. And that is an actionable offense for breach of fiduciary duty by a beneficiary, but not against you.
But I'll give it to you straight.
That wasn't your issue and you didn't do it.
I handled the trust where late on in the game, 17 years after the death, the family figured out that, oh my gosh, this subtrust should have been split, and it was going to be a taxable estate if it all got added into the survivor's lump. And we went ahead and did the split. We did it in a way that didn't create a tax problem with the way that the bypass trust should have been treated. So again, no harm, no foul as to income tax. Filed a late 706 showing this, and then showing the split, showing the subtrust. The IRS accepted it. 17 years after the fact. And think about it, does the IRS really want to take a case where they're seen as beating up on a widow or a widower? No, no.
But it could be very different if they're both gone.
It could be very different, but actually, there was a case in Santa Clara County where an attorney down there, both parents were gone, and after the second death, that attorney filed, I think it was 8 years there, filed the first 706, updated all the 1041s, did all the depreciation, carried it forward, amended where necessary, and wound up filing the second 706. What they found out, though, was because they did all those amendments and there was depreciation that should have been taken after the first death that never was, they wound up getting a refund on that case. So it really, it pays us to be aggressive, not aggressive in terms of fudging, but aggressive in terms of doing this after the fact and letting the IRS know so that the IRS can say, okay, no harm, no foul. It's not that dire a place. Yes, it should have been done, and in my case that I'm working on now, it should have been done 30 years ago, but we're still gonna be able to fix it.
Yeah, and where you don't have any changes, you're almost never going to get a beneficiary that is going to want you to go back and split the trust because they don't want to pay the expense. They don't want you to account for 5 or 10 or 15 years. They don't even want you to take the expense to account for 2 years, quite frankly. So a lot of times in those situations, the agreements come forth very quickly and easily.
Yeah. For the gentleman in the back, yes, these are all the things, the terrible things that could happen if we don't fund the sub-trust. Just get it done. Honest to goodness, we can fix this. This one's not the end of the world as long as we fix it. And sometimes it's a matter, as Tracy said, of getting the beneficiaries all to agree. What we don't want to have happen is that this goes unfixed, surviving spouse amends the trust, messes over certain beneficiaries, and now we have a dogfight while you're on the scene. We want to make sure that we've fleshed out that litigation early, where it's clearly not a result of your inaction.
And you will potentially, or you may have already had cases where you have the surviving spouse coming to you, wanting you to come on. And perhaps she's still competent, but she knows she's failing health-wise and she wants to do that. And she may be incredibly adamant. She is not doing this split. It is not happening. No way. You can forget it. And those ungrateful little stepchildren are not to know any of her business. I know that's probably rare too, but let's just suppose for one moment that that happens to you. It would sincerely be my advice to you that you may not want to take that case, because while she's directing you, that isn't going to help you when she's gone and they're coming after you.
Okay, these are the possible strategies, and there may be even more for dealing with this failure to fund subtrust. You can amend the trust if both settlers are living. If you have a power of attorney that allows you to amend the trust, I would do that cautiously as the fiduciary.
Yeah.
You can seek a court order to reform the trust, to say, hey, this is simply impossible. You can fund it late, and believe me, fund it late is not a bad option. You can look for trust authorization to use book entry so that you don't actually physically segregate the two trusts, but you are at the end of both of their lives going to deal with it as a 50-50 trust. You can obtain unanimous consent. We have had many situations where we have a trust reading in our office and all the beneficiaries are there and they sign off on the deal. You can use IRAs creatively if you have a Q-tip trust, and sometimes you can use them when you don't have a Q-tip trust by making Q-tip elections. And then sometimes we'll use promissory notes as placeholders, where we say, okay, the bypass trust never got funded. The target on that funding should have been $1.2 million. So what we'll do is we'll give a non-interest bearing promissory note from the survivor's trust to the bypass trust, and interest doesn't start accruing until the second person dies. That has also been used. That one, quite honestly, if you're on the scene, I would much rather do that going in on a 17-200 and getting the court to approve it, because there's all sorts of arguments around that.
So I want to really be clear on this. We are trying to, as you pointed out, give you best practices, but also give you real life solutions to real problems, because it's not always possible to use the best possible practice. I will get to you. But the point that he's talking about of getting all beneficiaries' consent, while I do think it is a protection, there is nowhere in the probate code, so do not go running back to your attorneys and saying, Frank and Tracy told us we could do this and it would be just fine. There is nothing in the probate code that actually allows a trust not to be funded just because the beneficiaries consent. However, if they have informed consent, they have signed a waiver, I think it is a good protection for you that you've informed them, they've had an opportunity to weigh the options, and they've come to this decision. So I just want to make sure you're aware of that.
On this topic.
So I just have a quick question. I mean, if you want to fund it late, but you can't go back to, you don't have the information to go all the way back to the beginning, what are you going to do?
You have to kind of guesstimate the best that you can.
In the case that I'm talking about, the 30-year case, the properties have all changed, the stocks have changed, whatever. The IRS only asks for a reasonable basis consistently applied when you can't make that kind of determination. So I use that standard. We went back, we appraised what we could, we figured out what we could, and we're about ready to go in on that case. I'm definitely sure we're going to go in on a 17-200 petition to lay it all out in front of the court and let the court approve it.
One more.
So Frank, when you get this unanimous consent to avoid funding, do you do anything in particular to memorialize the fact that real property is typically split into, equal B for purposes of ultimate reassessment or
Yeah.
step up?
We do a trust distribution. When we get the question is, what do you do when you get the unanimous consent? The answer is, we do a trust distribution agreement that memorializes everything that we just agreed to.
You record the real property.
Well, it's
If-
already recorded in the main trust, so it was never split.
But now it should have been split at that point.
If
you're
the
funding,
agreement was,
but you're getting
yeah.
an agreement not to fund, so it would never be split.
Right.
That's how I understood your question, is if you have an agreement not to fund the subtrust, do you change title to the property? And the answer would be no.
Let's call Frank and Tracy. Okay, the next one is probably my favorite, and probably Tracy's favorite too, co-fiduciaries. You want to talk about that? Ooh, you hear the whole crowd going, ooh.
So this truly, I believe, is rare in your profession, and I think some of you have gotten suckered into this and quickly learned that you will never, ever, ever do it again. But there can be compelling stories, and there is this tension between, and it really comes across when you look at the estate planning versus the trust administration. So as a trust administrator, I'm going to tell you, never ever take a case as a co-trustee, blah, 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 that's ridiculous, and this is all the problems. Well, he has real life clients sitting in front of him that are aging, and they're trying to come to terms with the fact that they're losing their ability to manage all of their finances, and they're not ready to give it up. And they truly do need a co-trustee. And it would be ideal for them to have a professional who actually knows what the hell they're doing instead of son who has no idea what he's doing and is going to mess it all up, and you're going to have to clean up the mess years later. So there is a practicality why people ask you to come in as a co-trustee. And it is dangerous for you. There's no question about it. But as we're dealing with an aging society, I think you're going to be asked the question more and more and more, because as a dignity matter, they're just not ready to give it up. Yes.
What about an agency agreement or agency standing instead of co-trustee, where you have a limited, matter, and therefore you don't have all that liability, et cetera? Why don't they do it that way?
Scott, that's a great way to limit the liability, is to do it simply under an agency agreement, basically a power of attorney. So you may have to amend the trust to allow the trustees to appoint agents, or you may have to draft a new power of attorney also just for the non-trust matters. So that's one way to go. I think you still have a problem whenever you have living, breathing clients and you are being asked to come into that family and to take control of their finances, and they still have control of their own finances. You've still got that liability out there. So one thing I just want to put out there, remember we have a California Supreme Court case now that says that even though a trust waives accounting while the settlers are alive, after they die, beneficiaries can come in and demand an accounting to make sure that elder abuse did not happen. So if I was going to, I'm the estate planning guy, but I'm also the litigation guy. So I'm going to be the first person to say, if you take one of those co-trustee situations or co-agency situations, then you will start doing your accountings day one. Period. End of story. Trace.
Right. And here's the reality for you guys. Banks are taking very large cases as co-trustees, believe it or not, because they don't want those millions walking out the door. And you may find you don't want those millions walking out your door either. So as a practical matter, it's really easy for me to stand up here and say, oh, never take a co-trustee case, that's ridiculous. But if you have a $10 million trust in your lap, you might want to take it.
I've seen fee schedules that have a 50% premium when they act as co-trustees.
Yeah, the comment was, I've seen fee schedules that if I'm a co-trustee, I'm charging a 50% premium because of the risk factor. I think the other thing you have to, in your fee agreements that you have to put in there, is that in a co-trustee situation or in any trustee situation, you will do annual accountings, even if they're not served. But you will do those accountings, and they will be an expense of the trust, and the client will pay for them, or the trust will pay for them.
And
period.
I think you need to have a client that has a willingness to provide information when there is no duty for them to provide information. So if you're going to serve as co-trustee and stepmom is adamant that she doesn't want any information, that's going to be a lot more difficult for you. But if stepmom is actually willing to give you some substantiation for the money that she spends, even though it's her money and she isn't actually entitled to, but now you're co-responsible for that money. And I can guarantee you that woman can be a spitfire, and she could be going to bridge clubs every day and playing cribbage. She could even still be driving and doing all of her own stuff, but just wants a little bit of help. The minute she dies, her capacity is going to come into question by those stepchildren. Well, did she really have capacity? You were acting with her as co-trustee. I don't think she really knew what she was doing. All those ATM charges were truly for her? What was she doing with all that money?
And if you have the Iowa farm boy who absolutely refuses to tell you what's going on in their entire financial life, run. Yes, sir.
What about the position of trust protector as an alternative to the co, where you're being asked to sort of act in more of an oversight role for another trustee?
Okay, the question is, what about trust protector, where all you are doing is exercising oversight? Those are such nice words. I love them. And I do estate planning, and I hear, it's kind of like Tinkerbell. It's going to be the trusted protector. Independent oversight and control. Isn't that fiduciary duty? So what does it buy you? You still have to know what's going on with that family, and if you don't, you've got a heck of a liability. So sorry, I don't see that as buying you anything. And I know that this is my profession. A lot of attorneys write themselves, they know that they can't write themselves in as trustees, so they write themselves in as trust protectors. Yeah, right. That's a lawsuit waiting to happen. Yes, sir.
Sometimes I've suggested a trust protector when I think the reason they want a co-trustee is it's too hard to trust somebody else with all the money. And I suggested they put in a trust protector and just go ahead with a single independent trustee. And sometimes that solves their concern.
The idea is maybe that but again, your question begs a question, and that is, you can suggest a trust protector, but that really only works to give them kind of, the peace of mind that there's going to be somebody looking over your shoulder. It still requires that they resign and that you're not going to be a co-trustee.
Right. It only works in a situation where the issue is trusting somebody else to manage it. It doesn't work in a situation where they want to do it themselves.
Right.
So
Okay.
I'd like to address
Please.
the trust protector. Are there any bankers in here? Okay.
Now, former bankers, we can go ahead and say bad things about you guys.
So
Please do.
By the way, I want to thank the people who are former bankers in the crowd. Thanks to you, there's finally an industry that's lower on the food chain than lawyers.
So trust protectors in general, I don't necessarily love them when I have a professional fiduciary in place and the trust protector is a layperson. I think they're problematic, especially if they can remove without cause and for no reason. I don't like that. However, I have seen a lot of trust protector provisions that are much like lawyers at banks. They don't really have to do a damn thing. They don't have to review documents. They don't have to read anything. They don't have to take any action. They're just there. And they get paid. Now that seems like a pretty damn good job. But I have not seen it applied in real life as to, is your standard of care really that low? So I do want to point that out. But I've seen a lot of provisions where all they can really do is appoint a new trustee or remove a trustee, but they don't have any responsibility for anything.
Good with co-fiduciaries? Have we beat that horse? Okay. Improper charges. We're now kind of coming up with the accounting issues. And this is probably one of my favorites, simply because I do a lot of tax work and I also do fiduciary representation. And what this problem here is that you are the trustee, you are the agent, you're the conservator, and doggone it, you are the kindest people I have ever met. You really try to do a good job for far too little pay, and you're doing too damn much. And what's worse is you're trying to save nickels everywhere you can. So what you do is the house needs repair. So what you do is you hire a handyman. Or you pay somebody under, the family member's cousin under the table. People, the probate code and the tax code agree that if you do not have W-2s, 1099s, invoices, receipts, you don't get to take those as proper charges against the trust. What's worse is, I'm not picking on any one errors and omissions policy, I'm picking on all of them. Of the 5 that I reviewed, 4 of the 5 carved out home repair as something covered. So the only way you can protect yourself is by hiring a licensed contractor and paying them above the table, not under the table. So this one really, it comes up there. And then the other place it comes up is non-licensed, non-insured providers. You inherited that wonderful man, that wonderful woman who's taken care of mom and dad forever. They're unlicensed, uninsured, being paid under the table, no W-2s, no 1099s, and no workers' compensation coverage anywhere. Can we say attorney's nightmare?
So I've had that exact case we came on as conservator. The person who had been the care provider was being paid under the table, had been there for over a year. He loved her, didn't want her to go. That is a tough call. You have this elderly gentleman who has been taken care of by this person who, even though from our standards there's a payroll issue, was giving good quality care. And he's attached to her. So now as the conservator, you're faced with, oh my God, do I fire her immediately and bring in these strangers and have even more problems with this person? Do I continue to pay her like that and have my attorney yell at me because she's really mean? What do I do? And so what we did in this particular situation is we got her, we had to pay a fee to her agency, which wasn't really an agency. It's one of those fake agencies that pretend that they 1099, but you guys know what I'm talking about. So we had to pay a fee to that agency, and then we had to hire an employment attorney to go back and calculate all of the lost wage and hour claims and try to settle with her. So what I did, this man was really, really attached to her. And she was doing a really good job. So we went to court under 172, or no, not 17200, it wasn't a trust. We went to court to say we would like to do these things. We would like a retainer for this employment attorney of X, and this is the benefit that the estate will receive by taking care of this now rather than later. We've already rectified the situation. We know she's being paid properly now, but there's this claim, and we want to take care of it now, not later, Your Honor. And in Contra Costa, he was fine with that, and we were able to do that. This was a fairly large estate, though. There was money to do that. If you're working on $100,000, you're not going to have that ability. Yes?
What we've done, Tracy, is we have agencies we work with who will hire the person. And if they're not willing to hire them, then we usually get rid of them because there's some reason they're not willing to hire them.
Right.
So,
but you still have past liability, and that's not you personally, you didn't hire them, but that wage and labor claim doesn't go away because the person went away. And they actually can even come back. The gentleman died within a couple years. That could have been a creditor claim against his estate.
Let me give you the nightmare scenario, Noreen, because this is really, it gets worse than you think. Imagine, if you will, this under-the-table caregiver has worked for you. The client passes away, and now they go get another job. And that's where they hurt their back. Didn't even happen on your watch. Any good workers' compensation attorney is going to ask the question, were you ever previously injured? Well, yeah, I strained my back when I was helping this nice man that I was helping out. Now what you've got is you've got a workers' compensation claim that's dragged you in, the estate in, and there was no workers' compensation insurance, and That's when the wage and hour claim is filed, because they also discovered that this person was not being paid properly. Oh, and by the way, you'll probably catch a claim from the person who provided the services saying, and they promised they were going to give me money as part of the estate. Oh, jeez, really? People, this is one of those places where, we talked about places where Tracy says, don't be a co-fiduciary. This is one of those places where I'm really hardcore. Thou shalt not hire people under the table, especially caregivers. Period, end of story.
So the other thing too is, let's say you come in after, maybe you're the trustee, not the conservator. You had nothing to do with these caregivers, the person's passed away, you're stepping into the role as trustee. You may want your attorney to go ahead and send those care people or the people in the home notice to creditors, so that if they think they have a claim that they weren't paid properly, we can get that out of the way right then and there,
Right.
versus after you've distributed the trust and holy cow, we have a problem.
In that case that you talked about with the wealthy family, where you fixed the claim, was that a claim that was actually made?
No, it was not made.
Potential claim.
It was a potential claim. We knew there were problems because we knew how much she was working and we knew how much the agency was paying her. So we knew there was an issue. But she had not made a claim. But just because an employee does not make a claim doesn't let you off the hook either. So we wanted to get out ahead of it.
Sandy has a question, then the lady in the back. Sandy.
Well, this actually happened many years ago. Couldn't happen today. But we had a live-in caregiver who, when we took over the client's situation, we said, okay, come in, bring your papers, we're going to get you all registered, etc. This was a live-in caregiver. She had no green card.
Correct.
She was illegal. So because she was a live-in and was very attached, we stopped paying her. We held her salary. Upon her signing papers, we advanced part of her salary to an immigration attorney. And to get her, now this was a long time ago.
Yeah, you could never get away with this scenario today. So I'm going to ask you to shorten it up a little.
I was in another place then. But anyway, so I know that. I'm just saying that the no green card was another thing that.
Undocumented workers,
And this is a live-in person.
Right.
Who then had to be physically removed.
the whole issue of undocumented workers and undocumented live-ins, I've got one word that's going to scare the crap out of everybody, excuse my French, trafficking. That's now being viewed as trafficking. And it's very, very common in the Latin American countries. It's very, very common in the Filipinos, among Filipinos, that you have live-in workers that come with the family. Under today's laws and today's enforcement, you have all sorts of violations of immigration laws, and you have trafficking claims. Lady in the back.
So I have a geriatric care management company,
Mhm.
Innovative Healthcare. My question is, we recently had a case where the wife has all the money in her trust and the husband is penniless. And first he hired us to do an assessment, and we said, okay, the wife is of sound mind and she can hire her caregivers, she can go live in a residential home. So the trustees released the funds for them to rent the home. But as soon as they went into the home, the husband cut us off. And now he is making improper charges, saying that he's the caregiver, he's hiring all these people from the street, he won't talk to us anymore.
Okay, you have the caregiver's question, what if I don't know who's got the legal authority to do it? And this is one of those things that it's going to come right back at you. Probably not the right question for this group, because if you are the trustee, you have the legal authority to do what you got to do. If you're the conservator of the person or the estate, if you're the agent under a power of attorney or an advanced medical directive, okay, we know who's got legal authority. In that situation where it's husband and wife and who's going to do what and what's going to go where, at that point, somebody may have to file a conservatorship action to determine that husband is not the person legally authorized. Yes, sir.
Is there a statute of limitation for these kinds of caregiver claims?
Oh, boy. There is, but I don't know what it is. This is one of those areas that, quite honestly, the question is there a statute of limitations for a caregiver claim? And this is one of those things that I immediately kick out to employment counsel.
Yeah.
Because it's a whole different animal that I don't want to be playing in and you don't want to be playing in. It's much better to hire an agency that's going to make sure that there's full compliance.
And one reason, just to go back to that, there is a statute, but I also don't know what it is. But the reason we wanted to get in front of it is because there's daily penalties, whether a claim has been filed or not. So if she were to ever file a claim, it was just going to increase and increase and increase and be that much larger. One more thing I want to touch on with regards to this section. Your fees, while completely proper and you're licensed and all of that, when you're a trustee, please make sure, or a power of attorney, or something where you can pay yourself on a regular basis without court approval, please make sure you're submitting those bills and paying them timely and not saving them all up and paying them in one big lump sum at the end of the year, or saying it was wages for last year and paying them in the following year. That is problematic. You are professionals. You have professional in your title. You are expected to bill like a professional.
Where we get into trouble is you've saved up your invoices, it's the end of the year rush, you've got 4 months worth of invoices, and you don't get paid until the following January, February. There's a real problem there with the tax reporting aspect of it. There's a real problem there of the income and expense reporting of your trust accounting. So this timing stuff is really, really important. And yes, we do teach that class on how to get paid. Yes, ma'am.
Frank, under the stable payments, going back to that, there's on the listserv, there's always the questions, anybody have a good referral for a handyman or woman for this or that? And we live in a rural area where licensed contractors are very scarce.
Yeah.
Very busy. So what is your recommendation? I mean, you're saying under the table, to me that means you're not reporting it via 1099 or W-2, but there are, if it's less than $600 or whatever, you don't have to report it.
Right.
So what is
The question is, what happens if you just don't have contractors who can do this stuff and you need stuff done, you're living in a rural county or what have you? The answer is that person, that handyman, runs his or her business like a business. They give you a quote. You give them a check. They give you a receipt. And if you've gone over the $600 threshold, you give them a 1099. As long as you're getting invoiced, that takes care of the tax aspect. That takes care of the can you report it as a proper credit against the estate. Yes. What that doesn't protect you on potentially is your malpractice insurance if something went sideways. And for those of you who remember the Santa Clara County cases a few years ago, that was one of the issues in that and one of the conservatorships there is that the repairs were not done by a licensed contractor. And we faced potential. We came in on that case not representing the conservator, not representing the conservatee. We came in strictly trying to get coverage under their malpractice policy. And so we had to make sure that case got settled around that issue. So.
And keep in mind, what's the size of the repair? If you're having a handyman fix a little hole in the wall and patch and paint, okay. If you're having them do a complete remodel, there's an issue there.
And in that situation, it was a pretty extensive repair to make the house habitable and another house ready for sale. Okay, our next issue, failure to due diligence. And this, I'm not, believe me, this, okay, I've got to cop to this. Tracy will tell you that I am the attorney that takes a case first and figures it out later. Yeah, when you do it, it's scary.
When he does it, it's scary too, by the way.
Well, because we've seen the cases where you've got this great case. They've got $1.5 million in the bank. They've got a great house that's repaired. There's an issue there maybe as to competence, but they can go ahead and age in place and they've got the money to pay for it. And you're thinking, this is a great case, except for the fact that the trust was written by an attorney who was told by the clients that their kids would act as trustee and they shouldn't get paid. So it explicitly says no trustee's fee. And you take the case. And I read the trust, or Tracy reads the trust, and we go, horsey hockey. Or you take the case only to find out after you've taken the case that everything they own is uninsured. Failure to due diligence. Trace, what are the kinds of things that you're seeing that really, if our clients would have just, and you're our clients, if our clients would have just done some diligence, we could have avoided?
Well, do we have new fiduciaries a couple years into this? New. Okay, so I have had a lot of newer fiduciaries call me, and they've done exactly what we've told them to do. I'd like you to review this case. And the case could be a good case. It has a lot of real property. The property is going to be sold. There is going to be a lot of money in this, but we don't have a dime to our name right now. And that's a good case for an experienced fiduciary that has some seed money. It is not necessarily a good case for a new fiduciary that can't fund, because regardless of whether you have a dime to your name as trustee, you have to insure that property, and you have to pay for it some way or another. And if you can't afford to pay for it, you're not off the hook. So a lot of my more experienced fiduciaries will take those cases because they have money in their business to be able to fund some of this stuff until the properties sell. But be cautious. Just because you don't have money doesn't relieve you of your duties.
Probably the other thing is realize that in your first 15 days of taking on a new case, one of the most important things you can do is an insurance review. Making sure if there's an automobile, if there's real property, if there's a business, that all of the insurance is properly in place. If you do not have a good liability insurer on speed dial, get one, because you can bind coverage quickly. And you can also be named, the estate or the trust and the fiduciary can be named as additional insureds on all those policies, but you've got to do it quickly. There are cases where a fiduciary is taken over and then suffered a catastrophic loss simply because they hadn't had time to look at the insurance picture. If I had my druthers, and I realize I'm talking about an ideal world, this would be part of your pre-acceptance review, is getting a good balance sheet of all of the trust property, all of the trust investments, finding out is there insurance on all the insurable assets, finding out who that financial advisor is, and is that financial advisor competent to come up with an investment plan, and if they're not, you're going to call Scott. Got you there. You want to make sure that that stuff is all done before you take the case, and that your attorney has looked at the documents so that you know what the Sam Hill you're dealing with. That is what we're talking about in terms of doing diligence. Yes, ma'am.
I have a little war story for you.
I love war stories.
I was recently appointed administrator of an estate with the same, only asset was a house in La Habra. Nice house, big house. Kids didn't want anything to do with it. I was actually brought in nominated by a creditor of his. House had a lot of debt on it. I don't have my letters yet signed from the judge. Everything takes too long in LA. But I decided to go there anyway with my unsigned letters, and maybe the locksmith would cooperate, and we could break into the gate with a big padlock on it. So I get there, the gate's wide open, driving, look around, house burned down. Burned down the week before.
Yep.
Now, I'm not appointed yet, technically.
Woo!
Knowing what I know about mortgages, I said, he died in June, but it started foreclosure just now. I called the lender, and guess what? They had lender placed insurance on it, so the house is totally insured.
Good.
We may end up making money, because now I still got the land. If they settled the claim on the house, I got 2 big pieces of real estate sitting there.
But can you imagine if we just changed 2 dates and you are now appointed and the next day the fire breaks out? I mean, I'll guarantee you that's one of those times that you just kind of, your heart goes up in your throat and you just want to die. Yeah. Now, the improper investments angle, in our neck of the woods, we have Chevron. I don't know what it is, but people who work from Chevron are one step away from cult status. I want my Chevron, please keep my Chevron, don't sell my Chevron, I want my Chevron. It's the weirdest doggone thing. So they've got an entire portfolio in Chevron, and it makes no sense. Or they've got an entire, whatever their employer was. And now you inherit this portfolio and the market does something stupid, which can happen at any time. Markets do that. So you're not hedged at all. You're not spread out. The risk is not spread at all. So this aspect also. Now, is this one of those immediate kind of, the house can burn down? No. But within a reasonable time, you have to conduct your financial review and do your diligence there. The two documents that I think Tracy and I both jump up and down and scream and cry about, your investment plan and your care plan. Those two documents are the basis of what we're going to use if anybody makes a claim that you acted improperly. And that investment plan should be done and looked at annually, and your investment performance should be looked at quarterly, at least. And if you do not have an investment advisor who honors your work well enough to do that, find another one. If you don't have an attorney who really answers your phone calls, or if you don't have an attorney who's not willing to look at these cases before you take them, find another one. Scott.
2 points on concentration. So the law says you have to diversify. It doesn't say you have to do it right away.
Correct.
So
a reasonable plan.
And you can retain some of it as long as it's a reasonable number. So we use 5%. So you can tell a family, yes, we're going to keep Chevron. We're just not going to keep all of it.
Right.
And you can do a 2 or 3, or we've had courts approve 17,200.
Right.
A 5-year plan to sell it, because if you sell it right away, he'll die and you'll pay a bunch of taxes you didn't need to sell. But if you don't, you'll have oil prices drop like they did 3 years ago, and
Correct.
their value will be halved. So it isn't about selling it or not, it's about protection and doing the plan and getting it approved.
So Scott is advocating a 17,200 petition, again, to review what the financial plan is, if it's going to be drastic, or if you've got beneficiaries who are screaming, crying, and jumping up and down. The other thing is, if the client is still alive, amend the trust. If there is that much attachment to that Chevron stock, amend the trust and waive the protection of the probate code that says that you can't be over-concentrated. Get it in the trust and say, settler was a lifelong employee of Chevron who believes in staying in this stock, and therefore the trustee is under no duty to diversify the Chevron stock. That will protect you also. Yes, sir. Oh, then over here. Sorry.
Yeah, next.
In the trust document, really protect you where it says, there's a concentrated asset, and I'm directing the trustee to hold on to that asset, and I waive any requirement to diversify the portfolio. Does that really protect you?
See the bobbleheads?
Yep. Yeah, if the client was competent and the client understood and was able to amend their trust and understood what they were doing, understood the protections that they were waiving, then yes. And in that situation, I've actually been involved in where I was the second attorney, kind of almost like a certificate of independent review, to come in and make sure that the client understood that and understood the risks.
So
and I signed off also.
There's an important distinction here. So when I was talking about co-trustees earlier and you being responsible for the acts of stepmom, the beneficiary, the settler beneficiary, their wishes are always paramount. Absolutely, 100%. As long as they're competent to make those decisions, they can do whatever they want with their money any old way they want to do it. And as their trustee, you can follow that direction. Where the problem comes is their stepchildren aren't going to fight them while they're alive, because nobody wants to risk their inheritance. They're going to wait until they die, and then they're going to come after you to say, well, she wasn't competent. Because if they go after her now, she can prove she's competent. They wait until she dies, and it's a much harder battle. And that's the distinction I want to make when I was talking about being a co-trustee and being on the hook for their actions versus following a directive that is written by the settler. In fact, if you did not follow that directive, you could be liable for breach of fiduciary duty, and you've been waiting patiently.
Yeah. And if the attorney drafts that amendment, realize you've got one up already, because that attorney is going to be the witness after that settler dies. And implicitly, the judge who's known that attorney for 20 years is going to say, well, I know that attorney. He or she would never have drafted that if the client wasn't competent and didn't understand. So that really does protect you. Okay,
You've been waiting very patiently.
Getting back to the insurance issue, another area of exposure is, especially I think you're co-trustee, you have the co-trustee out there who's the trustor, and they're out driving yet, and they're not properly insured. So I think that's another thing that you
Yeah.
I advise people all the time to come in, where they're putting me even as successor trustee, I tell them, you've got a multi-million-dollar estate, how much auto insurance do you have?
Right. And then not only do you have auto insurance, but do you have excess liability or umbrella coverage on that, which, again, it's part of your review. And then I would never counsel you ever to be dishonest, but I don't think it's dishonest to say that the car is broken if you just happen to pull the distributor wires. Just saying.
So, in the case, you're talking about the case where the trustor still has capacity. If they don't have capacity, could you go in with a substitute judgment to do that, or is that?
You absolutely could.
The question is, could you go in if your client does not have capacity, and again has that concentration in the Chevron stock, could you go in on a petition for substituted judgment to reform the trust to allow for that concentration? And absolutely yes.
And you actually may want to, because a lot of times their children don't want you to sell it. They're anticipating inheriting Chevron stock, and they want to inherit Chevron stock. So where you have a family that's communicating well and they're telling you what they want, that may be what you want to do.
Yeah, my question is, in terms of the investments, if you have a lot of cash, or that's the only thing that they have, but it's like, they have like $50,000 and then they have a house worth $450,000, is a concentrated investment too much cash?
Not necessarily. You're looking at a whole picture here. What are their care costs for the next year? What is their income? What is their burn rate? You may need every ounce of that $50,000 cash. If they're making more income than 50,000 is kind of a low amount, but if you were talking a couple $100,000, sometimes it's perfectly reasonable to keep couple $100,000 in cash because their care costs are over $100,000 a year.
We have a case in the office right now where the burn rate is something close to about $12,500 a month, and not unusual. So on that, in 6 months, you're going to need 75 grand. Period. End of story. So just because you have a lot of cash in your estate doesn't mean that you're derelict in your duty to invest. You just have to look at remember, the guide here is what are the objectives of that trust? And if the objective is taking care of mom, taking care of dad, then having a lot of cash may be the absolute right thing to do.
And the thing is, you're at a real disadvantage because if you get sued, the people that are suing you already know the outcome. They already know what happened. You're on the front end looking down the road trying to make your decisions. They're looking back saying, well, that was a bad decision, look what happened. Well, of course they have the benefit of hindsight, right? What you need to prove is in that time, based on the information that you had, you made a sound decision based on that. And that needs to be in your file. And don't get me wrong, I know it's a pain in the ass to document. I get that. It's difficult for us to remember to do it. But that is truly the only thing you have to rely on because we know what the result was. What we need to show is, okay, yeah, it was a bad result. But, because nobody ever sues you if it's a good result. Let's just get that out there right now. So we know it's a bad result, but in the moment, your decision was based on sound principles that made sense.
And I'm going to modify Tracy's response in just like one sentence in there, T. You said that, based on the information you had. Remember, you're also under a duty of reasonable inquiry. Right. You're under a duty to do your diligence. So this next one, things like hidden litigation. Tracy already talked about it, about finding out about caregivers. Were they properly paid? Do they potentially have a claim for under wage and hour laws? Are there beneficiaries out there who've already rumbled? I took care of mom for 4 years and I never got paid a penny. That's a potential creditor claim.
Do you have people squatting in your property so you're not even going to be able to sell it until you evict them?
So these are all things that are just basic diligence. The obvious one, and the one that I hope that we all know and love, is making sure you're going to get paid, because that's, we'd like to get paid too. So let's see. Okay, so again, we beat the attorney's pre-case review to death, I think. This is really, this is one of the, I was thinking about this. We were talking in the exhibitor hall. I've been teaching now for PFAC, it's been about 15 years now. And 15 years ago, attorneys weren't paying attention to you at all. Now they've figured out that you are good and valuable clients. Insist upon being treated as good and valuable clients. And that pre-case review is something that an attorney should do. Okay. Communication tips and traps. Okay, now we're getting to it. Because this, I think, is the number one reason why attorneys, doctors, fiduciaries, any professional, this is why we get sued. It's not because we did the right thing or the wrong thing. It's because we didn't communicate effectively. Think about it. They did a great study. I can't remember who did it, and it's been done many, many times, of doctors. And when you've had a death in that medical history, what is the number one determiner as to whether or not that doctor is going to get sued for malpractice? And the answer is his or her bedside manner. Did they communicate? Now, where you've got battling beneficiaries, it's multiplied. You've got all sorts of problems. So let's talk about communication. Yes, ma'am.
I was at a thing and one of the guys suggested that when you make a decision like diversifying stock, you're sitting here, okay, what am I going to do? If you actually write a memo to yourself in a way to explain your rationale for making a particular decision at a particular time, you keep that in the file so 2 years later, so why did you do that? You say, why did I do that?
Yeah, your notes are very, very important, but what we're talking about here is communicating to the beneficiaries. And I will be the first to cop. Sometimes it's not appropriate to talk to them. Sometimes it's not appropriate to communicate. And then your notes are going to be huge. But what are we going to do with our battling beneficiaries? Trace.
I think we just disinherit them all and tell them to go away.
That works.
No.
I got a cousin named Chewy who can simply take them all out. It's faster, it's cheaper, it's easier, and the pot is easier to divide up.
I would say the number one reason we have that cases escalate to either pre-litigation or litigation is a failure to communicate. And it's usually family member fiduciaries who feel like they don't have to because they're the trustee and they're in charge and they just have to follow my orders. Obviously, as professionals, you're not taking that stance, but you also have beneficiaries that can be difficult or prickly, or you know what? You don't have a half an hour to burn up on the phone with them explaining the same damn thing again and again and again, and it's eating up your client's money. And so there sometimes is a tendency to just cut them off. And sometimes that's appropriate, but other times what it does is it just leads to escalation.
One of the things, the best thing that I can think of, remember you are charged with treating the beneficiaries fairly and equally.
Right.
One of your notes might be, what is my communication policy? And making sure that they know about it. Okay, my communication policy, and I will tell everybody in this room right now, I tell all my clients right now, that my partner Tracy Regli is probably the best customer service person and telephone communicator I have ever met. She calls people back, she takes their calls, she communicates with them. I am the worst telephone attorney who ever lived. The reason is my day is different than hers. My day is usually 6 meetings a day, 6 one-hour meetings a day, and then I have 2 hours to coordinate with my staff and do all that stuff. I can't return telephone calls. And for that reason, I tell my clients, Tracy does not tell her clients this.
I do not.
But I tell my clients, I will never charge you for email time. And the reason is, I can scan 30 emails and respond to them in an hour. If I took 30 telephone calls, that's 8 hours. I have to charge for that. And so that's the way I've diverted my clients. Now, in my email communication, I've adopted certain practices, and some of these apply to fiduciaries as well. I use email because for me, it forces them to think about their question. I don't have to listen to 20 minutes about this war story about Aunt Sadie. And you're sitting there going, is there a question in there anywhere? And you finally get it. So that's it. And I do not give out my cell phone number. You're different. You have to be available because there are client emergencies. So I understand that. You may want to consider having a second number so that you know what's coming from family and what's coming from the gig. But email for me provides a written record of what I said. And this next thing here, my policy is whenever I have multiple parties, I tell them up front, I'm going to copy all. If one beneficiary asks me a question, I'm immediately going to put the other beneficiary addresses in there on the copy line, and everybody's going to see a copy of the question and the answer. See, that way, I've treated all the beneficiaries fairly and equally, and everybody sees that your brother, who is just so sugar sweet whenever mom's around, is a real pain in the butt who can't wait till she croaks. And then, you know, Tracy you use the next business day policy on your telephone calls, don't you?
I do. I really try to return them same day because it just really irks me to have unreturned messages, but I am not always successful at that.
I would really, again, pet peeve for me, I would try to stay away from text. They're harder to keep, they're harder to print out, they're harder to make a record with your clients, with your beneficiaries. Keep it to email. And this is one reason. One fiduciary I know has a smartphone, that's her personal phone, and a dumb phone, that's the client line. The clients can still get in touch with her, they can still leave her a message, but the dumb phone doesn't take texts. So it forces them to use phones appropriately. Other things that you have?
Yeah, my fiduciaries are using text more and more because that is the practical way of the world, and I do dislike it an awful lot for the same reason that Frank spoke about. 99% of the time it's going to be fine because you're not going to have a problem. But if we needed a record, that's not what you really want to put in front of the court if you can help it. And I find that my fiduciaries are a lot more laxed on text than they are in a formal email too. So as I'm looking at their text, I'm like, I can't do that. I can't put that in front. I mean, it's not that bad. I exaggerate for effect. But what we want as attorneys and as professionals is we want the court to see, look at, we're reasonable people. We're acting professionally. This person over here is being totally unreasonable. But when you're responding via text in the heat of the moment, it's real easy for a nitpicky beneficiary to get under your skin and your response to not be as appropriate as you would like the judge to see.
I got to be really honest with you. This person has saved my bacon so many times, and it's now expanded to more people in the office. Because what I will do is when I've got one of those emails that make me go, whoa, or that I've got to write something that I go to, it's typically Tracy, but it could be the other attorneys, it could be my paralegal, it could be almost any of the office, and I ask them for what I call a snot check. I want you to read this and tell me, is it too snotty? If you have to see this in front of Judge Sugiyama, would you have a problem telling the judge what Frank was thinking and feeling that day? And they pare it down. I can't do that with texts. With text, I'm just flying, and let me tell you, I am a really nice guy. Sometimes. There are also times when I can cut with a single word, and my choice of words is designed to start World War III. I raise daughters.
So I know as a practical matter, most of you probably use text now, but if you have a highly contentious case, and you know that going in, I would really encourage you to use a more formal form of communication in case it does need to be in front of a judge at some point.
Just a quick tip on the text. If it is something that's just not mundane, then I'll forward it to my email. It doesn't have quite the same paper trail or dating, unfortunately, but do that. And then also voicemails. I've had some really lengthy, contentious voicemails. And if you have the right setup, you can forward those, to an accountant.
So that everybody over here could hear it, the comment is there is technology where you can forward, I mean, everybody's got the technology for this one. You can forward a text to your email. And you can also forward a voicemail to your email, and you'll just have a voice file attached to that email, and then you save that thing, you print it out, you save it, you do whatever, so that you do have a record of this email chain went south and it wasn't me.
The other thing that can be effective is to utilize your attorneys. If you have a particularly difficult beneficiary You do not need to be raked over the coals 3 times a week for a half an hour each phone call.
3 times a week or 3 times an hour?
Well, have your attorney write them a letter and say, all further communication is going to go through my office. What this does is they don't always understand your value in hourly time, but they know I'm expensive, and they don't want that coming out of their inheritance.
We do have a case where the beneficiary, it was 3 times an hour, that was a slow day. And this guy honestly thought that he was the Lord High Chancellor, the greatest attorney who ever lived, and he knew everything, and he was calling our client, he was calling us, and we finally let everybody know. We sent him a letter, and we let everybody know, our receptionist, our office manager, our calendar coordinator, our paralegals, everybody knew. And at the reception desk, there's actually a sign that has his name on there, written communications only.
Yeah.
And then you announce that to the rest of the family, saying, "This is it, gang, and I'm treating you all the same way because one of you is a pill." Okay, other communication tips and tricks. I just want to make sure that we get in there. We've talked about them briefly. We've talked about investment plans and care plans. These are those 2 annual documents. They're talked about in the NGA ethical standards. This is just good practice. If you have authority over the person, you want that care plan. If you have authority over the estate, you want an investment plan. And this, again, I cannot tell you how many investment advisors I've run across who don't understand that as a fiduciary, you need a written investment plan. Do it. The other thing is, again, your errors and omissions insurance coverage does not cover investments. You're not supposed to be, some great financial guru. It will cover you if you have acted reasonably and diligently and hired an investment advisor who's come up with that investment plan, and you exercise reasonable oversight and control. And I'm here to tell you, I can defend reasonable oversight and control as a quarterly meeting all day long. Tracy, do you have any other perspectives here?
No, I like that.
Okay. So you are shifting liability, and quite honestly, that's what they're getting paid for. So your investment advisor, your care advisor is not going to be upset. Oh my gosh, you're trying to, yeah, this is what you're selling. You're selling your expertise. Okay, notices of proposed action. Every year I think we talk about these. We love notices of proposed action and section 17-200. Getting the word out. Whether it's sometimes we don't, because we don't want to poke the hornet's nest.
Right.
But for me, section 17-200 was the greatest gift that the dear Lord ever gave to fiduciaries.
I really like these too, and there are times when we purposely choose not to use them. And in fact, if you attend my session tomorrow, you will find that we did not, in fact, use a notice of proposed action to sell a property in the case that went to trial. We knew it was heading that direction anyway. I needed my fiduciary to have money. We had no money in the estate. I was selling that property come high or hell water. High or?
Hell or high water?
Hell or high water, thank you. Because we needed money, and we needed money to fund that litigation. So I could not afford to have that beneficiary object, because then we'd be forced to go to court, and I was 100% certain they would object. So it was a strategy. There is a risk. And the fiduciary and I discussed it, and we decided that the risk of not having money was greater than the risk of having a licensed professional real estate that was not related by blood or marriage, having it on the MLS, having it show open houses, having multiple offers, and showing that we accepted the highest possible offer.
So these, again, are just strategies and communication strategies. The other notice that sometimes we give, sometimes we don't, is the notice to creditors. Sometimes we don't want to poke that creditor. In a trust where we have the option, we can either do it, it's not required, so you either have a 1-year statute of limitations for a claim against that trust estate, or you can do the notice of proposed action and shorten it down to 120 days.
Notice to creditors.
My fault, thank you. Notice to creditors and shorten it down to 120 days. Sometimes we don't want to, because we don't want that creditor coming out of the weeds. And sometimes we don't want to do a notice to creditors because by the time you get the case, it's already 9 months old. It's only got 90 days to the end of the 1-year statute. Why give them 120 days from the notice? So there's a little bit of strategy going on here. Yes, sir.
Sometimes in these trusts it says trustee shall pay trustor's liabilities in a post-death situation. And sometimes it says trustee may pay.
Okay.
And whenever it says may, I always ask the beneficiaries if they would like me to do this. And they don't want me to pay.
That is shocking.
Yeah, the trustee shall pay versus the trustee may pay. Look, as the trustee, you know you've got an obligation to settle the debts of the estate before you make distribution. Period, end of story. Now, you have the option of saying, yep, that's a good claim, or no, that's not a good claim. So I think even if it says shall or may, you still have that option there. What you're really seeing is in some trusts, you do not want the trust liable for the debts of the estate. For example, IRA trusts are now becoming more and more common. You really don't want the IRA trust to be obligated to pay the estate's debt. You want the living trust to do that. Same thing with any kind of spendthrift trust, any kind of special needs trust. You don't want to obligate that trust to pay the beneficiaries' obligations. It's designed there so that it won't, so that it supplements rather than is liable to the creditors. So there are certain trusts where you don't want to do that. Again, this is the place where you want to talk to your attorney and figure out what's the guiding principle behind that and just determine whether or not you're going to pay those debts. Yes?
Yes, back on your note about consider asking for a short protection period of 10 days.
Uh-huh.
In what situation might you use that with what argument?
Okay. The question is, this is something that, again, when you do your first report to the court, or when you're on 17200 and you're being appointed as the trustee, you know that under an estate that you have 10 days. 15 days to respond to an objection or to make an objection. And with a trust, it's 45 days. 45 days is just too doggone long to respond to a notice of proposed action. So go in and ask to shorten the time. What you're doing is you're saying, Your Honor, we're putting this trust under your authority anyway. We've already opened up a number. So instead of waiting 45 days, so for example, a notice of proposed action to sell real estate, that one's really typical. Do you really want to give notice to everybody and then have them dink around for 45 days? You're going to lose a good buyer. So you want to make it faster. In that contentious case, you want to give notice. You want to have the sale approved. But you don't want to give them until next doomsday to make that objection.
And that would be in the case of whether court supervised or non-court supervised?
Non-court supervised also. You're opening it up under 17200 and saying, Your Honor, here's our situation. We have disagreements among the beneficiaries. We're going to have to use notice of proposed action. We're going to be selling real property. It makes more sense. Everybody's available to receive their notices. It makes more sense not to use 45 days. It makes more sense to use 10 or 15 days so that we have an appropriate notice period, but we also aren't going to lose buyers. Yes, ma'am.
What is the best timing for the sending out of the notice of proposed action? We have a buyer when you're ready to list the property.
Oh, we got a fun one on that.
I've done it a few different ways. If I'm doing it in a trust, and I'm only talking about trusts here because the states are real specific on how you have to do it, but it's only 15 days. If I'm doing it on a trust, sometimes I will do a preemptive. If you have a really good real estate agent, such as Andrew DeVries, he can give you a good number that he thinks the house is going to not fall below.
Yeah, the bare
it might be
minimum.
a little different than what he's listing it at, but he can give you a pretty good estimate, unless it's 2008, that it's going to at least sell for this. And so what I will then do is a notice of proposed action saying who the agent is, what the commission is, and that we are going to sell it in 45 days for not less than X amount.
Or X amount net to the estate.
Correct.
So something like that. So now what you've done is, as let's say that you've said that not less than is $600,000 and you know it's a $700,000 property, okay, then there's no further notice of proposed action necessary as long
Yeah.
as everybody's
Don't get too crazy though. Like, I mean, $100,000 difference will raise caution. I mean, I'm usually talking maybe a $25,000 difference between what he thinks it really will sell for and what it won't go below. Because if you go too low, you're going to force an objection.
We're in that last 5 minutes, and we've kind of hit all of the hot topics that we're seeing. Are there any questions that you had that we did not get to? Powers of attorney. And the question again on powers of attorney was? Why don't I want to work under, or why don't? I don't have a problem with licensed professional fiduciaries acting under power of attorney. Just realize that you have a fiduciary duty there, and all the stuff we've been talking about, such as keeping your financial records, doing your accountings, knowing full well that when your principal dies, you're going to be questioned by the beneficiaries. And remember, powers of attorney die when the principal does. So you have no authority to act the minute they die.
Yeah, I have a problem with my fiduciaries acting under a power of attorney where she spoke, where we don't think the person was competent to sign that power of attorney.
That's the other one.
That puts them at real risk, and I am really adamantly opposed to that. It is a solution that people offer so we don't have to do conservatorships, which I understand are time-consuming and expensive. But keep in mind, my client is not that little old lady. My client is you. So I want you protected. I care about the little old lady, but I really care about you.
So I'd really rather see you as the trustee under a trust and the agent under a power of attorney so that there's no financial matter that goes uncovered. But I want both. I really do. And I'm much more comfortable if those were signed when we know that the testator had competence.
Agreed.
Last two, yes.
And we'll stick around for a little bit, but then we have to get to our lunch session, I think, because we're at a table.
Are we done now?
We've got 3 minutes.
3 minutes, okay.
I was going to say, one of my first clients as a fiduciary was a woman who did not get along with her daughter and had it for a long time. So I was acting under a power of attorney. I got into a situation, got into a situation where I was waiting for my fees. Some things happened and the daughter came in and talked to the mother and had her sign the power of attorney, essentially throwing me out.
Right.
I had to talk to an attorney to try to litigate my fees.
Yeah.
And ended up with half of the amount because I was waiting for a house to sell.
Sandy just had a question about how the agent under a power of attorney got messed over on her fees. Yes.
Given this was a lot more extensive than just a copy outline.
The question is, can you have a PDF of the slides? Send us an email. I'm happy to share a PDF of the slides with you. Thank you all very, very, very much. So we have to go to the...
Yeah, we're due at a table.